This is Angie, by the way. I'm listening in just so everyone knows who's on the phone.
Hi there.
Hi there. How are you?
Good, thank you.
This conference will now be recorded.
Okay, you can go ahead and start the meeting now.
Hello, good morning, everybody. I'd like to call Policy Committee to order today. We're going to start with the minutes review. I know the minutes were circulated. Is there a motion to approve?
So moved.
Second.
Dr. Bechtel, is there a second? Yep, by Mr. Giacalone. All in favor say aye.
Aye.
Yep. Any opposed? Hearing none, no opposition, we'll move on to the rule review update. And I will turn it over to Kim.
All right, thank you. We have the rule review update, and also we're looking forward to 2021 and the rules that we'll be bringing to you then. So we're hoping to start in January. It's a smaller group, but some of those rules are ones that you use quite a bit, and that our licensees use. The sexual misconduct rules are up for review, and the delegation rules, as well as controlled substances for self and family. So those are some rules that you do deal with quite a bit. And then we have the schedule and the spreadsheet. You do have rules that you're going to adopt today, and the CME rules with the mandatory 1 hour duty to report. We had our JCAR hearing and our public hearing, and those will be ready for you in January at the January meeting. So unless there's questions, I don't have anything further.
Are there any questions? Okay, seeing none, we'll move on to the rules at CSI. Okay.
So the first one that we want to talk about is the temporary military licensure. So you're adopting the kind of the new chapter of military licensure rules today. And then this one is an add-on to that, coming from Senate Bill 7 that was passed and effective in April of this year. And so we did get the recommendation from CSI. I think for the first time ever, they required us to make some changes. So they wanted us to add information about how we were going to prioritize. And actually, Rule 3603, 4731, 3603 that you're going to adopt today does reference that. So I am recommending that we amend 3604 to reference the processes that we have in 3603 that will be effective by the time this rule goes through. And then they also wanted us to add something that we were waiving fees. The statute requires us to waive fees, which is why we didn't have it in the rule, but it's fine to put it in the rule as well. And so that's added as paragraph H. So if the policy committee is okay with that, I think we'll ask the board to look at it this afternoon or later today, and then I'll notify CSI.
Kim, I had a question. On waiving fees, that doesn't make us responsible for the cost of the PCI investigation. Does that have to cost go to the person applying for the license?
I was having trouble hearing that. Could you ask that question again?
In waiving the licensure fees, we're not responsible for the cost of BCI investigation.
Betty, can you mute your computer? Thank you.
I was going to mention that again.
We're getting some feedback from you, so if you can keep yours on mute until you talk, that would help us. And Mark, you can, I think, ask your question again.
In waiving the fees, one of the concerns I had was the cost of the background investigation that would occur. Are we responsible for the cost of the background investigation, or is that a cost that the applicant has to pay for?
So under the law, they're required to go through the background check, and the background, they're required to follow the laws of the background check. And so they would be required to pay for that. It doesn't come to us, but the way that it's set up, they have to meet the requirements of the background check statutes, which include paying the fee for the background check. The fees that are waived are just our licensure fees, I believe. But that's a good question. Thank you.
Kim, I asked you that yesterday. Can we make sure that that's clear so we're not absorbing the BCI background checks?
Are you suggesting that we need to change the rule, or that we just include that in our instructions to the licensees?
As long as it's just so it's clear, if you can make it clear, so we're just not absorbing the cost. So in some way, either through the rule or by instruction, clarify it so we're not absorbing a background check cost.
Okay. I think it is, the statute and the rule, the way you read them together. I can work with Joe to make sure that we have instructions for these types of licensees that. So I'll work with Joe on that.
Okay, if there are no other questions, do you want to move on to the next one, or do you want to vote, Kim?
I think if we could have a vote that those amendments are okay, and that we'll take it to the board to finalize that.
Okay, is there a motion to approve? Dr. Bechtel, and is there a second?
Second.
Dr. Johnson, all in favor, say aye.
Aye.
Any opposed? Hearing none, that carries. And we'll move on to the light-based telemedicine rule.
Okay, so you have a packet with a lot of information about the comments that we've received on these light-based rules. And we've also gone back and talked with PAPC as well. So I think the bottom line is, I think that we need to alter the way that we're dealing with PAs in this rule, and because the statutes surrounding PAs, especially 4730.21, already lay out how a physician, a supervising physician, and a physician assistant need to work together with respect to the competence of the PA to perform the procedure, the type of supervision that is given by the supervising physician, and the number of PAs that can be supervised at one time. Those are already taken care of in the statute, and are slightly different than what we are doing, what we have proposed in this rule. So I think that is the basic concern of the physician assistants. So I made some draft changes to the rule to address that, to treat physician assistants differently and in accordance with the statute dealing with supervising physicians. And then LPNs, RNs, and in certain circumstances, cosmetic therapists would have the set number of procedures that they needed to review and the type of training that they needed to take. They would have the on-site supervision required, and the physicians would only be able to supervise up to 2 individuals. But for PAs, it would revert to the requirements in the statute. So I think that's a significant change, and I think we would like to take it back to PAPC to make sure that we're addressing their concern, and take it to the nursing board as well, because we are making recommendations related to some of their licensees, LPNs and RNs. So I think that's what we would like to do. I also would very much appreciate input on the definitional concerns that were raised. I'm struggling with that a bit, and would definitely appreciate some insight on those particular provisions.
Mr. Chairman, Dr. Soing,
Yes.
on the light-based rules, and Kim, are the light-based medical devices including a vascular laser? It's just not clear in the rules. I can't tell what it applies to, and does that require some clarification?
That's what I'd like some input on from the policy committee.
Yeah, that was the nature of Eric Plinke's concern in his memo. And so, Dr. Bechtel, grateful for your 2 cents about that.
Yeah, in the comment on what represents a vascular laser, it specifically discusses what type of lesions, skin lesions, are considered vascular in nature and therefore amenable to treatment. One of the things about vascular lasers is that the energy of the laser is absorbed by the blood, the hemoglobin in the blood, and then that dissipates energy that causes the blood vessels to kind of blanch down. And in the proposal, it talks about what lesions are considered vascular. It talks about the pathophysiology of the laser technology. I looked at that again over the weekend, and I think it's satisfactory.
So if you'd be so kind, I think that the question Mr. Plinke had in his memo was, are we right to define a vascular laser as a light-based medical device, to clarify that in the rule? That feel comfortable for you?
Yes.
Okay. Okay, Kim?
All right, thank you.
Great. Thanks.
Just to comment one thing too, if you look at some of the comments as you've looked over those, there are a few comments about patient safety, and these rules and regulations are all really focused on patient safety. Basically, what we're doing is expanding the ability to do vascular lasers to RNs, LPNs, and PAs, not cosmetologists where they do the laser hair removal, but just to the RNs, LPNs, and PAs. Vascular lasers are probably the safest of all the lasers as far as patient safety. They have a lower risk of scarring. That's why we chose this laser to be the one to maybe expand the scope of practice. There is really rigorous educational requirements. 8 hours of classroom education, which is standard for all the laser courses in Ohio. They have to observe 15 cases and then perform 20 cases under directed observation by a physician. So we've chosen one of the safest lasers, and then we have a really robust educational system. And the other thing is they can't supervise more than 2 nurses or PAs at one time. And I know the really respected Cleveland Clinic, they sent 2 articles to review on laser safety. One was in regards to ablative lasers. We do not allow ablative lasers because of the risk of scarring. It's much greater than vascular lasers. And then the other article was published in a foreign country, not an American-based literature review. So I do feel comfortable about patient safety. We've put a lot of effort, a lot of guardrails around this, a lot of robust education to really protect the public.
Thank you.
Thank you. Yes, Dr. Schottenstein.
All right, thank you so much. So, Kim, if you'd be so kind, the concern from the PAs was substantially that previously the rule was more restrictive than the statute in terms of what statute allows them in their supervisory agreements. And so you rightly so set out physician assistant authorization to meet requirements of their statute. But as you said earlier, left the other criteria for the RNs and the LPNs and their certified medical assistants and such. Do the RNs, does the nursing board similarly have statute that governs their authorization for supervision that would similarly potentially allow them more leeway than our rule does?
I don't think so, but I think we would like to run this by the nursing board to make sure that they are okay with the rule. So I did revise the memo that the rules are pending at CSI, and we do need to get back with them about our responses to the comments that we've received. But I think, given the nature of these rules, it would be good for us to reach out to the nursing board and PAPC just to make sure that we've satisfied those issues and we're not raising other issues. So I think we'd like to do that.
Thank you so much.
Yes, Mr. Giacalone.
I don't mean to go back to something, but because the comments raised it, issue with hair removal and tattoo removal. Mark, can you comment on why those should not be in the bailiwick of cosmetic technicians, or what separates that, for example, from the vascular laser treatment, that we would treat those differently?
Well, I think the cosmetic therapists have been doing laser hair removals for quite a while. That's been established by rules, and they've been doing that for years. With
lasers, with medical devices? I mean, the same.
Yeah. There's a specific laser hair removal laser is very specific, and they've been doing that for years.
Okay.
Now
And they'll continue to under this rule, but they'll have training requirements.
So Bob, the cosmetology therapists that are currently doing laser hair removal, they will be able to be grandfathered and continue to keep doing that. But any new cosmetic therapists that are going to start doing laser hair removal for the very first time will have to go through extensive educational instructions.
Okay.
In the removal of tattoos, that is very, very complicated. You have to choose lasers specifically based on the tattoo pigment itself. And so the pigment would determine the type of laser. There's a much higher incidence of scarring. Some people have their tattoos removed by lasers and then end up with scars that are even worse than the tattoos. So it's a very challenging process with potential risks. So I think that's something that one would consider down the road, but not currently.
Okay, because I know there's a comment that maybe Kentucky or some other states permitted that. I just was curious if that was okay. All right, thanks.
All right, if there are no other questions, do we need to take a vote on this, Kim?
I think if you could just vote that we'll take it back to PAPC and to the nursing board, and then we'll let you know what happens after that.
Okay, so Dr. Bechtel made the motion. Is there a second?
Second.
Dr. Johnson, and all in favor say aye.
Aye.
Yep. Any opposed? Hearing none, we'll move on to the weight loss prescribing rules. And, I'll take this one because if you recall at last month's policy committee meeting, we actually decided to get more information on this rule. And part of that was predicated on the fact that these rules have been, or at least the feedback we got, that they've been similar over the past several years. And perhaps it's time, given some, further review on these rules and where we stand. And the decision was made at last month's meeting for me to reach out to some key opinion leaders and have some discussions and obtain their feedback and report back to you. And I want to tell you that I did that about, I think it was around 2 weeks ago. And we had a lot of well-renowned experts, physicians from very good institutions like the Cleveland Clinic. We had, pharmacists on the call. We had a lot of people that really treat obesity, people that represented obesity associations nationally, et cetera. And I got a lot of very valuable information and feedback. And what I want to tell you is it was actually a lot of feedback. And I actually we asked for some additional written comments. And we were just getting those in last week and the week before, and even very recently. And some of them are very excellent, well-written, and robust. What I'm basically saying is that I'd like to continue to digest this information. I don't want to rush this process. And I think that it would be helpful for me and for all of us to continue to review those comments, and then perhaps next month provide you with a more robust update on where we're at and what we've learned. I can tell you a couple of things because there was two general themes that we noticed in some of those comments. One was, is there any potential opportunity to enhance, telemedicine type visits for, some of the wellness checks that are required by rule was like one group of comments. And then the vast majority of comments were based on, the issue of phentermine being, labeled as an acute treatment, and are there any opportunities for chronic use? And there's just a bunch to unpack with that one. I think that I think we just, as I mentioned, we'll get some more information and be able to provide a more updated, provide a more robust update, next month. So on that note, with the weight loss prescribing rules, I'll tell you it's still a work in progress. We really appreciate all the learning and feedback that we were able to get from people that are doing this on a daily basis, and I actually appreciate their time and effort and the comments that they've given us, which are helpful. But in order to get it done right, we're going to keep going through the process. Are there any questions on the weight loss prescribing rules? Yes, Dr. Schottenstein.
So thank you so much for taking your time and doing that, number one. And number two, will we also have access to either a transcript or minutes of that interaction that you had with those experts?
Yeah, so we planned on actually trying to provide you guys with a robust memo. And at first, that was what we were thinking of doing for this particular meeting. But then we kept getting comments. And like I said, even recently, we gotten some. So I didn't want to shortchange the process. So the answer, I guess the long answer to your question is yes, you will be getting and hearing and receiving that information that we've gotten. And then we can, have a more broader discussion at that point.
Dr.
Great, thank you so
much for taking your time to do that. I'm sure it takes a lot of time. And
oh, actually, it's no problem, and it was very educational for me. And some of those physicians are just incredibly, they're so passionate and knowledgeable. And I just think we're lucky in Ohio to have even those physicians that were willing to take time to advocate for their patients also.
That's great.
Mm-hmm. Okay, and if there are no other questions, we'll move on to the hearing rules.
Okay, so the hearing rules are pending at CSI. You had approved some minor changes to those rules, but our hearing examiners brought up an issue that they would like to see one of their rules amended so that they would have the ability to hold virtual hearings even when the the emergency is over, on a party's motion or on the hearing examiner's motion. And so that is included in your materials as an amendment to 471303. And if the board is okay with that, what we will do is then refile this with CSI. We'll have a short comment period again for the public. But the hearing examiners felt that this would be helpful to have in their tools.
I think that's just wonderful, Kim, that we would be able to afford that, because for a lot of our licensees, this is taking off work. It takes a great deal of time. It may be expensive, and it's just the flexibility is I think it's great. Also, it may allow us to have more hearings in terms of scheduling process.
Great, thank you.
Any other comments? So do we need to make a motion to refile with CSI, Kim? Yeah.
Yes, please.
Is there a motion to approve? Or refile? Yeah, Betty and Mark, and all in favor, say aye.
Aye.
Any opposed? Hearing none, we'll move on to the consult agreement rules.
Okay, so there we have a couple of things that that we're doing here. So with the consult agreement rules, the Board of Pharmacy is responsible for rules for pharmacists, the medical board for physicians, and now physician assistants, which is new, and the Board of Nursing for advanced practice nurses that are able to do this. And so we had a meeting of the three, board representatives, and so what we would like to do is first we have the proposed rules from the Board of Pharmacy. So if there are any comments on those, this is our consultation process. I think I have been notified of some minor technical, like typographical errors, and I will share those with the pharmacy board. But if there are any other concerns that you want to raise, I would appreciate that, and we can provide that feedback to the pharmacy board. And then second, we have our proposed rules to add PAs to our consult rules for physicians. And then if you are good with those rules as drafted, then we'll submit them to the pharmacy board to get their comments before we start kind of the whole process. So that's kind of what I'm looking for. Any comments on the pharmacy board rules, and if you're okay for our draft rules to go to the pharmacy board to consult with them.
Kim, can I just ask, how is the relationship between you folks and the pharmacy board in terms of sitting down and working through language? And is that going well?
Yeah, it's going very well. Yes.
All right.
Like the typo, right? The prescriber and some of the other typos in there.
Right. There's a couple. There's a numbering issue as well. But I'll share that offline.
That's fine. That's fine.
Okay. I think if there's no other questions, if we could just have a vote on the two items in the memo, and then I think we should take it to the board later as well.
Great. So is there a motion to approve?
So moved. Dr. Johnson?
Thank you, Dr. Johnson. And a second?
Second.
That's Montgomery. Yep. All in favor, say aye.
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 Any opposed? Hearing none, that carries. And we will move on now to the legislative update. I think Chelsea has that for us.
Good morning, and thank you for allowing me to provide the legislative update before the committee. Over the past month, the legislative team has been working to monitor legislative activity on many bills, and it is shaping up to be an extremely busy lame duck session. As you may recall, Senate Bill 246 is the Occupational Licensing Reciprocity Bill. We worked with the committee chair and the bill sponsor to address some of our concerns regarding the retention of the board's ability to make a determination on whether or not an applicant has adequately met Ohio's qualifications for licensure. I am pleased to report that in committee last week, our requested changes were adopted. These amendments allow for greater flexibility in making determinations on applicants' fitness to practice. These changes not only allow for more flexibility on the part of the medical board, but for all boards. And I'd like to thank Nate Smith, who was instrumental in both drafting and negotiating the changes that will benefit all licensing boards. Senate Bill 364. Yeah.
Yes. Were you, was there a discussion about look back beyond the limited years if we're dealing with violence or sexual related offenses?
So on Senate Bill 246, this bill has a 5-year look back limitation. And there is some language in there that allows us to, with the fitness to practice language that we had added, we have a little more flexibility to take into consideration if there have been, disciplinary actions on someone's license. Their license has to be in good standing. So I think that with the fitness to practice language that we had added, we have a greater degree of flexibility to look at these applicants a little more closely than we did before we got that language in.
So, but the look back would deal with discipline on the license as opposed to any previous behaviors which might be violent or sexually related. I assume that would be taken into its licensure to begin with, but I would hate to see it so narrowed that we could not look back on things that maybe don't result in discipline.
Yeah, I don't know if if Nate or Kim want to speak to that. It's my understanding that the limitation is 5 years for any offense, unless it has to do with the license specifically.
Yeah, I'm going to defer to Nate on this one.
I think that I believe that Chelsea's working diligently on the 263 with the temporal limitation on the conviction piece. I think on the 246 legislation, we were successful in negotiating the ability for the board to look back on all licensure discipline and be able to implement our disciplinary statute to look at all licensure discipline. So I think we made some strides in relation to both prior discipline and conviction on 246, but there's still a lot of 263 is dealing with the same code section, so that's a concern that we're still trying to work through related to that temporal look back on those convictions in 263.
It's a big improvement. Well done.
Thanks. So then I'll move on to House Bill 263. That's the other occupational licensing bill. This one is the bill that requires the board to provide a comprehensive list of criminal offenses that would prevent a person from becoming licensed in Ohio. Since the last board meeting, we have been working with several other healthcare boards to develop a solution to our issues, as well as attempting to work with the bill sponsor and the committee chair on this language. Last week in the Senate Transportation, Commerce, and Workforce Committee, they had a third hearing, and we did submit testimony on behalf of the medical board expressing our concerns with the language and offering some suggestions for changes that would make the bill a little more palatable. The bill is actually scheduled for its 5th hearing again today. On Senate Bill 364, which would require Ohio to join the Interstate Medical Licensure Compact, Last time we spoke, I had updated the policy committee that the legislative team had traveled to meet with the bill sponsor in her district to express our concerns. She seemed to understand our point of view, and she advised that she would take our concerns into consideration, or take all information into consideration, rather. And since the last meeting, there actually hasn't been any movement on this, but we are continuing to monitor. I don't expect that we will see it move during this General Assembly, but I think we will see the language again early next year. We also continue to monitor House Bill 492, which would expand the ability of physician assistants to perform procedural sedation for the purpose of rapid intubation. We are aware of several stakeholders that have expressed opposition to this language. It hasn't seen much movement, but again, this was something that board members were concerned about, so this is a priority that we were making sure we keep an eye out for. And you may have noticed that several other bills were added to the legislative tracker since the last meeting. Senate Bill 236 authorizes the Director of Health, when adopting rules for Ohio's radiation control program, to deviate from the suggested state regulations for control of radiation if doing so is warranted and does not pose a health, environmental, or safety risk. We're watching this one because an amendment was added in House Health that would allow an anesthesiologist assistant the ability to order and direct others to administer drugs under a supervision agreement. We have spoken with OSMA and as well as the Ohio Society of Anesthesiologists, who have expressed a neutral position on this language, on the amendment language, rather. Senate Bill 305 would require insurers to provide coverage for telehealth services during the state of emergency. These bills and any others that, we pick up along the way are always, analyzed by the team. And if we think that this is going to move, I guess if it moves, I will update you at the next meeting, since the new GA will have started by the next board meeting. And as always, the updated legislative tracker and summary are in the board documents. That concludes the legislative update, and I'm happy to answer any questions.
Thank you again for a great and robust update, and the legislative tracker, again, well done. Very much appreciated by all the board members. Are there any other additional questions?
I had one question, I'm sorry, Mr. Chairman. On House Bill 388, the surprise billing bill, the discussion is, what is your evaluation of that bill's progress and flexibility? Since that's a really remarkable, that's a very important discussion that's happening politically and in the world at large. You describe it as hospitals have to provide upfront information. Does this require, do we know whether this requires, so that if I walk in as a consumer and I end up getting some test done by my out of my system, so I get a bill that I didn't expect and is not covered? How robust is that conversation, Chelsea?
Chelsea, I noticed your camera's off. I don't know if you're still on the call.
I thought I hit my mute button to unmute myself and hit my camera instead. So I'm sitting here talking to myself. So, yes. So the hospital is required to provide an upfront cost for any services that would be provided, assuming that those costs are not emergency in nature. So if there is some sort of test that is out of your network, the hospital would be required to notify you that it is out of your network. If there, and also make you aware if there is some way to have that service performed in network.
Okay. And what's the, how robust is that bill? I assume it'll be introduced next session.
It's had a third hearing in the Senate, so it's possible. Anything's possible during lame duck. So it's possible that this could go through. I know that, this is something that the Department of Insurance was supporting, and several members have, thrown support behind to prevent that surprise billing.
I just want to make one comment, Mr. Chairman. Chelsea did start by saying that it was lame duck season and corrected herself, but there is some humor in all of that discussion, given what happens during this lame duck season. Thank you, Mr. Chairman.
Correct.
Thank you, Chelsea.
Thank you. Thank you. Dr. Schottenstein.
Hi, thank you. Chelsea, could you speak to the federal legislation that we're tracking now, which is toward the end of the tracker, and whether or not we have the ability as a board to provide input on pieces of federal legislation that we find compelling?
Yes, so all four of the pieces of legislation that I have listed here, I would not expect will move this year. The Congress is also, getting ready to start over in January. So these bills have been introduced and haven't had much movement otherwise. If there's something that we feel strongly about or feel like it has potential to move, we can certainly weigh in with our congressmen and senators and try to, at least make our position known. But with these four specifically, I wouldn't expect that they're going to move this year.
And Chelsea, we can also, if need be, if it's that critical, we can testify.
Thanks, Chelsea.
Great. Are there any other questions? Okay. Seeing none, thank you very much, Chelsea, for that robust report. There's a final agenda item for Board of Pharmacy update. I'm not sure there is one, but if anyone has one, it doesn't look like there is. So in that case, I will entertain a motion to adjourn. And Dr. Bechtel, and a second. Ms. Johnson, all in favor, say aye.
Aye.
Opposed? Hearing none. This meeting is adjourned. Thank you very much.
This conference is no longer being recorded.
Thank you, everyone.
At 10.
Yes.
10.